Okay, good evening. Today we are going to learn about pleas. Pleas is in a criminal procedure unit or lesson. However, it is contained in criminal procedure code. In criminal procedure code, you will be required to read and understand section 207 and section 208 of criminal procedure code CPC. First of all, let's define what is a plea. A plea is where accused person is confronted with accusation of charge against him and given opportunity to formally respond to or to answer the judge. That is a plea. We say a plea is where an accused person is confronted with accusation of a charge against him and given an opportunity to formally respond or to answer the judge. Okay, remember that the judge is prepared by a prosecutor. So, when the accused is brought to the court, he or she is required to respond to the judge prepared by a prosecutor who had collected the evidence against him. However, in section 207 and section 208 of CPC, I mean Criminal Procedure Code, says the court is required to explain the charge and all elements of the offense to the accused in a language that he understands. The court is required to explain the judge and all the elements of the judge to the accused person in a language that he understands. Okay. However, if the accused does not understand the judge, this can be fatal to the case, and hence the requirement of explaining the charge and all the elements of the offense is required. So, remember that it's the mandate of the court to explain to the accused person the charge and the elements of the charge. But if an accused person does not understand the charge, it can be fatal, because explaining the charge to the accused person who does not understand the judge will be complex. However, read the case of Charo versus Republic. I said the case of Charo versus Republic, CHARO versus Republic, 1982, case number 308. Let's continue. Persons who are not represented by a legal counsel should be given more attention to ensure they understand the contents of charge by thoroughly explaining all the elements of the offense. Remember, there will be a scenario where an accused person does not have a legal representative. I mean, a legal representative is an advocate to represent him. So, the court is required to give more attention to such a person and to ensure they understand the contents of the charge by thoroughly explaining the elements of the offense. It is the accused's right to be furnished with a charge sheet or information. I mean, when the accused person is detained in the court, he or she have a right to be to be furnished, I mean to be given the charges that it has been brought against him in the court by a prosecutor. The charges should be sufficient to enable the accused to plead to the judge. Where there is more than one accused person, each must be addressed individually and their responses recorded as nearly as possible in their own words. The accused must plead personally to the judge. Let me explain. Where an accused or accused persons are more than one, they are to plead to the judge. However, the court is required to bring individual person to plead to the judge. Remember, in a judge sheet, where the accused persons are more than one, and they are suspected of doing similar offense, or they are suspected to have done the offenses jointly. Remember that it is recorded in one charge sheet. However, in this charge sheet, they are numbered in counts. Let's say the offenses are more than one. They are numbered in counts. And the accused person is required to plead to each count that is noted in the charge sheet. So, when the accused person are more than one, each person is brought to the court to plead to each charge in the count. Yeah. So, each person is brought to the court to plead to particular offenses noted in the charge sheet. And the accused person must plead individually. Let's say more than five persons are suspected to have done something. Each of them is brought to court to plead individually. They don't plead as whole. Each of them will plead to each offense recorded in a charge sheet. Okay, let's continue. Fitness to plead. Remember, there are some persons who doesn't have capacity to plead. So we are going to learn about fitness to plead. The issue of whether the accused is fit to plead may be raised by either the defense or the prosecution. A person is unfit to plead if he is incapable of understanding the proceedings. If one does not understand the proceedings, then he cannot. If a person does not understand the proceedings, means that he is not fit to plead to a judge. And a person who doesn't understand the proceedings cannot do the following things: put forward a defense. A person who does not understand the proceedings does not put forward a defense. Instruct an advocate. If you are not able to understand the proceedings, means that you are not able to instruct an advocate or your legal representative. Number 3, follow the proceedings. If you are not able to follow the proceedings, that means that you are not fit to plead. Remember, I said 3 things. 3 things that makes you unfit to plead. Number 1, put forward a defense. Number 2, instruct his advocate or your advocate. Number 3, follow the proceedings. However, an accused person may fail to plead if, remember I started with things that make you unfit to